So the Director of Child Protection Litigation is it's a statutory offer position, and it has an office to support it. It was one of the key recommendations out of the Queensland Child Protection Commission of Inquiry. So you see there it's recommendation 1317. In essence, what it is doing is trying to improve the outcome for children and families, and we're doing that through providing at the front end greater accountability for decisions and some oversight of some of those key decisions. So I'm tasked with trying to ensure, firstly, whether or not an application for a child protection order needs to be made, and if so, what type, and making sure that application is supported by the best quality evidence. So that's what I've just really gone through. Really the primary aim of my office and myself is and I'll take you through to the next. Looking at time. Where child safety, or the Chief Executive, is satisfied that a child is in need of protection. So this is after there's been a notification received, after there's been an investigation and assessment. Sometimes it's after agreements, intervention with parental agreements, or it's after emergency type orders. At some point along the way, where somebody within child safety forms the view that this child is in need of protection and that protection can only be met by a child protection order, now in law, child safety sends that matter to the Director of Child Protection Litigation. So it's an independent body. It sits within the Department of Justice and Attorney General, so separate to the Department of Communities and Child Safety. And there are in essence two main things that happen. One is on the left, you can see, so it's child in need of protection. We need an order. They must refer it. Equally, if there is a child that's subject to a child protection order at any point, somebody in child safety with the delegation forms the view they now no longer need to have a child protection order, they must also refer that to my office. Now, in terms of new matters, just to put it into context, because I know a lot of you are in the secondary systems, just so you understand what's happening. At the point a matter is sent from child safety to me, we're getting evidence. So they're tasked with putting together a brief of evidence. So you'll see all the supporting documents down there on the left, along with the reasons why. Why the child's been assessed to be a child in need of protection, what order is assessed to be appropriate, and one of the reasons why. And type of order. And then any other documents that are relevant, they're all sent through to us. Now my office is based in Brisbane, but we have a statewide service delivery. We're receiving matters from all over Queensland. Is there anybody here in the room from Child Safety? Is it 55 Child Safety Service Centres now? I think that's about the right number. We're getting matters from across the state. So in the first year of operation, so from 1 July 2016 through to 30 June of this year, we had just under 2,500 children referred through to us. Now, what we then do when we get a matter is, firstly, we try to determine is it a properly referred matter? So on the face of it, do we have what we need to make a decision? And if it's not, we'll ask for further information. Now, then what we also must do in law is we must consult with child safety. So if I'm looking at the brief and the reasons why it's considered the child's in need of protection and the type of order that's assessed as appropriate, if we have some questions by law or in law, we must consult. And that happens every day. There are lawyers consulting now from my office with child safety around what type of application should be made. Equally, if we decide that an application shouldn't be made, so there's no application made, we've got to consult and we can refer matters back. So there have been matters that have been sent to me in my office and it hasn't resulted in an application for a child protection order. That might mean that there's further investigations that need to happen, or it might also mean that through that consultation we reach an agreed position where we think the work can be undertaken through an agreement with the family. And that's happening as well. If we do go ahead and file in court, so we draft that application now and we're the applicant and we conduct the litigation. So Child Safety is a briefing partner. They're no longer a direct party to the litigation, but we rely upon evidence that we receive from Child Safety to run that litigation.